I want to just read you a potential instruction and tell me if you agree with it or if you see any kind of difference between your position and what I'm going to say and what the SG says. What if the court says, or what if we were to say that qualified conferral orders are okay if they tell the lawyer, listen, you can't talk about the content of the testimony or the manner of its delivery, but you can discuss any strategic consequences of the defendant's testimony, such as whether to take a plea, whether to call another witness, et cetera. Are you okay with that?
Yes.
Okay. Yeah. And I'll ask the SG whether the SG thinks that's consistent too.
Mr. Worthen, I just wanted to quickly follow up on Justice Sotomayor's line of questioning. And I wonder whether unconstitutional conditions doctrine might be in play. If you were to say that a lawyer couldn't advise a defendant during a long break about collateral consequences from his testimony. If I can't advise you, boy, it's time to take that plea. Mm-hmm. If I can't tell you about the consequences of perjury, maybe I'm excused as an ethical matter because I'm under a court order, perhaps, but I would have thought that our unconstitutional conditions doctrine would have something to say about unnecessarily chilling the Sixth Amendment right that's at stake here.
Now, are you asking from the no management perspective or the SG's?
The SG's perspective. I wonder whether that implicates unconstitutional conditions doctrine.
I don't want to put words in your mouth, but I think the SG would say that there's two ways to go about dealing with, say, perjury. One, if you're still on direct, you can try to fix it up as you're going on direct. Or if it happens on cross-examination, you can try to fix it up on redirect. Another option would be the defendant finishes his testimony. You tell the trial court something very important came up during his testimony. If we could just have a moment to talk, if we can just have a little bit of time, then at that time you talk to them, you investigate whether or not perjury happened, you remonstrate with them about your ethical obligations and his obligations, and then you would call him back as a witness. And then if the trial court were to be like, well, why are you calling him back as a witness? You could either say, it'll become clear in just a moment, Your Honor, or you could tell them, you would just have to tell them straight out, perjury was committed and I have to fix it before the end of this proceeding.